Well, we have all our commissioners back. Mr. Green, I see joined. There he is. Hi, Tom.
Hi, Brian.
Glad to see you. Thank you. We actually have 10 minutes before the scheduled time to start. And again, just in terms of
Right.
process, I think it would be helpful to wait a few minutes for that, so in case anybody's tuning in, especially at 11. And that gives me an opportunity to just talk through the memo that I drafted, this 2023-7. As the title says, it's a status report. It's purely informational. There's no decisions that I'm asking to be made. But what it describes is the general process I'm setting up for the commission in the antitrust study. And as I mentioned earlier when we were talking about the study of the ERA, the approach is multi-pronged, and it relies on, first, a series of presentations during commission meetings of the type that Mr. Green is going to be providing us at 11. And he or colleagues of his or other folks will be handling the remaining ones. I've scheduled them for every meeting from January through June, to take advantage of the fact that we can still legally conduct our meetings entirely by teleconference, which makes it a lot easier to do this kind of thing. And that'll give us 6 sessions, which I think is pretty substantial as a foundation for this study. So the way these will be running is that Mr. Green has a PowerPoint that I'll be his clicker. I'll be advancing his slides for him, but he'll be talking you through the content. And then with the time that's left over after that's completed, there'll be an opportunity for you to ask him any questions or discuss any of the issues that came up. So that's the first prong. The second prong is that I'm setting up these small working groups, currently to be populated by academics, experts in antitrust, and a couple of folks who are both former California DOJ antitrust enforcement lawyers. So I am going to be, in the next week or 2 weeks, starting to assign topics to the working groups and populate them from our list of experts. And then I'm also going to continue the recruitment effort. Like I said, to date, I've mostly looked at professors, but I want to include practitioners. I have a couple of great public enforcement practitioners, but I'll be looking to find some private enforcement practitioners who could also participate. And I'm also hoping that the groups, once formed, might recruit some members for themselves from younger faculty, rather than these established eminences that I'm really pleased to have recruited so far. I think if the members of the group can reach out to their associate faculty members, I think that might be a good way to increase sort of the diversity of perspective, make the group more inclusive, and also make sure that there are other schools of thought represented. But even if none of that happened, I think we have a stellar lineup. I'm really pleased with the people who have agreed to help us. So that's the second prong. And my intention is that they will write reports for us, and the reports will be objective. And as was discussed at the last meeting, will not include specific recommendations. They will describe the area of law that they've been assigned to cover. They will discuss perceived defects in that law, and then they will conclude by discussing possible reforms that would address those defects. I think it's valuable to have decided that these should be objective only and not include recommendations, because there's a diversity of views about antitrust. And I think it will be easier for the groups to reach agreement and complete their work product for us if all that they're doing is describing the present understanding of the law, problems with the law, possible solutions, what's on the table. If they don't have to actually advocate for it, I think that it'd be easier for them to reach consensus about an objective description of what's out there. So that is the second prong. The third prong, and I'm grateful to retired DOJ enforcement attorney Cheryl Johnson for this idea. She suggested it, and I have asked her to help me to set it up and get it going, and she's agreed to, which would be working with academics in California business schools and other relevant academic experts to conduct empirical and literature research on the effect of business consolidation in California. So the goal would be to either conduct original research or aggregate existing research, or take existing research that is not California specific and extract the California data out of it, so that at the end of that, we'll have a report that discusses empirically what's going on in California. So it's my hope that all of those threads will come together towards the end of this year. And the commission will then have the benefit of having had these introductory lessons from Mr. Green et al. And will then have in hand a pretty comprehensive report of the sort of the leading expertise in the country on antitrust that goes into greater detail in each of the subject areas that the legislature's tasked us with examining, and provides you sort of with a roadmap, a reference to existing conditions, and a menu of options. So that at that point, my hope is that we can then transition into deliberation. The staff will work to first present those reports for the commission. I expect it'll be a long read. You'll have a lot of homework then. But then do our usual process of figuring out what's a sensible way of moving through the material, what are the decision points, what are the contending issues. And I think there will be a lot of really lively meetings where we discuss these issues, because at that point, I expect that we will have a lot of motivated public comment on the issues. So that's the overall plan. That's what is described in the memo, and that's what we're starting today with Mr. Green's presentation. As I mentioned at a prior meeting, this is a little atypical for us in terms of sort of being a staff-driven process more than usual, but it's sort of operationally necessary in order to create some distance between these consultants who are going to be helping us out and the commission itself. And that distance helps us to preserve sort of the workability of these groups as informal collaborators in academia rather than as government decision makers. So if we maintain this sort of arm's length relationship with them, it really eases their operations. They won't be subject to Public Records Act requests or open meeting requirements or things that would really make the process difficult to manage. And so that's been my approach, and that's why I have been sort of driving it without presenting it for approval by the commission, and rather just as a staff-led operation. but I think we're getting there. I'm like I said, I'm really pleased. Everyone who's participating is doing it as a public service pro bono. Is really appreciated. I think that they're just general interest in the prospect of this being an important effort, and that California maybe will be able to make progress on this that would have national implications. So with that, I'm already a minute over. I'm gonna stop presenting my memo, and I'm gonna share my screen so that I can show Mr. Green's slides. And Tom, just let me know when you want me to go to the next slide.
Absolutely. Thank you.
Here it
And
comes.
thanks for doing this.
Yeah, no problem at all. I really appreciate your help. I am no expert at PowerPoint, so let me see if I can figure this out.
I think you just hit share screen and bring it up, but
Yeah,
that's easy for me to say.
I can share screen with no difficulty, but I want to maximize the display so we don't see all the clutter. Let me start with sharing screen. I will hopefully be better at this in February when we move on to the next topic. So there's the slide presentation.
Go to slideshow, which is up at the top.
Yep.
And then play from start. And it should be really big then. There you go.
All good? All right.
Absolutely.
Take it away.
Very good. Thank you. So thank you all for being willing to visit with me this morning about antitrust. This is an area of professional interest of mine. I'm both an antitrust practitioner and adjunct professor of law at what used to be called UC Hastings. You can see our new branding here. We've unloaded Tyrannus Hastings, who had quite a checkered history when he was still alive. So now we're UC Law San Francisco. So this, I think, is maybe the first time I've used this slide template, but in any case, from UC Law SF. So Brian, next one.
No. There we go.
So I am also an employee of the Department of Justice, and I do need to indicate that my views are those of my own and not the views of the Antitrust Division of the Department of Justice. Very important that I say this to you. Next slide. So what I'm going to try and do is just give you a really high-flying overview of antitrust and antitrust issues. And I have found it helpful, at least with my students, to just kind of give them just a sense of the history of this stuff. The bottom line here is that wherever there has been trade, whether it's been in Rome or Phoenicia or other places, there have been trade regulation rules to make sure that the marketplace works reasonably well for everyone involved. So next slide, Brian, if you would. So the most obvious analogs to the kinds of statutes that I enforce and that you will be reviewing are these two. So the Lex Julia, this is 50 before the Common Era, prohibitions against supply constraints. This is one of the concerns that we have when we talk about monopolies and price fixers, is that they're going to reduce supply into a market and then thereby increase the price of the goods being sold in that market. So we're before the time of Christ, and this is Roman law. 483 CE, this is towards the end of the classic, what we think of as the classic Roman era. The constitution of the Emperor Zeno basically prohibits both trade combinations, this is versions of what we might think of as price fixing, and monopolies. So, 2,000 years ago, people were worried about issues similar to the ones you will be fretting with over the next couple of years. Next slide, please. So this is this is Sir Thomas More. There was a movie ages ago called The Man for All Seasons. He was the principal advisor to Henry VIII until he decided that Henry shouldn't divorce his then wife and things got bad. But he was basically a Renaissance scholar, and this book that he wrote, Utopia, basically was saying that monopoly should not be part of utopia. You had to deal with these kinds of trade restraints. And so this is 1516. So I've jumped ahead basically 1,000 years. So the Tom Green time machine. Next one. And then that brings us to Elizabeth I. Such an interesting person. And let me just spend a moment or two on this slide. She, for her favorites, would issue what were called letters patent. So when we talk about patents today, patent in Latin basically means public. So she would issue a letter signed Elizabeth I. And for her favorites, she actually created monopolies. So if you were Sir Walter Raleigh, you were her friend and she would give you a monopoly. And it covered big parts of the British economy at the time: sweet wine, cloth, salt, iron, beer. Beer was particularly important because it actually was the best way to drink water. There would be low volumes of alcohol, but given the quality of water in the Thames at the time, this was kind of a big deal. It's, from an economist perspective, a natural experiment. Prices went way up once these monopolies were awarded to her favorites, and that created a whole host of problems. Next slide, please. So this is 1603. Shakespeare is still alive at this point in time. And so Edward Coke, it's written Coke, but it was pronounced Cook. So this is a really famous set of books, reports by Lord Coke on the common law. This would have been read by Washington, Jefferson, Madison, and ultimately people like Lincoln. And this is sort of part of our common law DNA. And this was a case that involved a monopoly on playing cards. And Sir Edward is saying that the monopolies are utterly void as against the common law. So they were illegal as a matter of a common law question. And he lays out what the Elizabethans thought were the problems, which actually are going to be the same kind of problems you're going to be worried about for the next 2 years: increased prices, reduced quality and choice, and reduced employment. So 1603, common law of the United Kingdom says monopoly's bad idea. Here are the effects. Next slide. This leads to 1623. Elizabeth is gone. I think James may be gone at the point as well, but in any case, so this is a statute on monopolies. The first one really in the English tradition that is clear is this one. Due to the odium of royal grants, footnote back to Elizabeth I, the statute prohibited monopolies. So the sovereign could not create monopolies for her friends. There was one exception, which was for inventions, for the true and first inventor of any new manufacturers within the realm for 14 years. So these would be legal, and they called them patents, and we still call them patents. So the idea is no monopolies, with this exception that we're going to give people, if you invent something new, then we'll give you a monopoly for a very specific period of time. And it's starting to look a little bit like us. Next slide, please. So I'm not going to trouble you with all of this, but so if you were talking to economists, I'm sure you will be talking to economists, they talk about a couple of implications of monopolies. One is prices go up, typically because supply is reduced, but prices go up. That's one of the reasons that people are concerned about it. And then there's something that they refer to as deadweight loss, which is the loss of efficiencies from a monopoly. So the idea would be if in a competitive marketplace, the market would have created 100 units of a particular product, but in a monopoly situation, there's enough power so that the monopolist sells only 80. That difference, that loss of what would have otherwise been done in a competitive marketplace, that's what economists refer to as deadweight loss. So those are the technical kinds of things typically we would look at, and you'll hear about this kind of stuff at least off and on in your next few years of this. Next slide, please. Brief history of US antitrust law. Next slide. So this begins really the semi-modern era. So this is the time of the progressive era, the beginning of it. So in the 1880s, particularly in Wisconsin, there are huge concerns about railroads doing price discrimination, giving special deals to big guys and hurting small guys. Some states, I think Kansas was the first, probably in about 1884, created what looks like a modern antitrust law. And then finally in 1890, the Federal Sherman Act becomes law. This was, Senator Sherman was the brother of General Sherman, who marched to Atlanta with his soldiers during the Civil War. This was one of the most popular statutes in the history of statutes. It was passed without a single no vote. So this was a giant deal. And it did a couple of really big deal things. One is it prohibited anti-competitive agreements. Think about price fixing in Section 1. And then it also addressed single firm conduct of a specific kind, that is the actions of monopolies. And I should probably tell you one of the kind of secrets of antitrust, just very briefly. So the reason we call this antitrust is that in roughly 1882, not to trouble you with dates, but a guy named Samuel Dodd, who was the general counsel for John D. Rockefeller's Standard Oil Company, he created the company as a trust. So competitors would surrender their interests in their oil fields, their refineries, whatever, to the Standard Oil Trust, and then get back trust certificates, and then they would be allowed to vote depending on their market shares. So the effect of this was to basically create a giant cartel in the oil industry. And the statute was referred to as an antitrust statute because that's this thing that so most obviously represented an effort by these private interests to combine in order to increase their profits and increase prices to the public. Next slide, please. So 1890, that was passed. United States, fairly slow out of the blocks. I mean, they're inventing antitrust. I mean, we'll see that the language of the antitrust laws are very cryptic. They were apparently designed to pick up the common law of antitrust, of competition from the states. So they are pretty darn cryptic. So judges and lawyers are having to invent it. Plus, there was not a lot of stomach to prosecute big companies, but partly, if not substantially, because of Theodore Roosevelt, the Justice Department brings a case called United States versus Standard Oil. It's the first gigantic antitrust case. Basically a year of trial for the time, huge numbers of documents, et cetera. The upshot of that was they broke it up. So what used to be Standard Oil of the world became Standard Oil of New Jersey, Standard Oil of New York, Standard Oil of California, which is now Chevron. So it broke up those various regional chunks of Standard Oil. But there was still enormous frustration. The public, by and large, was very concerned that this statute that they'd all supported, it was so popular in 1890, wasn't doing much. And part of the reason for that is there were muckrakers, a group of sort of investigative journalists at the time that were writing very extensive pieces about what was going on in various industries. The stamp I'm showing you here is Ida Tarbell. She wrote for a magazine called McClure's, which was just a huge deal at the time. She wrote a book about the history of Standard Oil. So you had basically very detailed, publicly available, widely read commentary about what was going on in various industries, oil being an obvious example. 1911, we got Standard Oil, reasonably good result. But there was a real stomach, a real interest in improving the law so that stuff could actually happen on a more regular basis. Federal Trade Commission Act is enacted. So that's in 1914. Also, the Clayton Act is enacted, and that prohibits tying and exclusive dealing, which we'll talk a little bit about. The Federal Trade Commission Act basically enacted something called the fairness standard, so unfair trade practices. So it gave broad discretion to this federal agency. It was a commission form agency. It has its own administrative court. But one of the really interesting and creative aspects of the early 20th century in terms of law and competition law. Next slide, please. So the US Depression, the part of the deal there was lots of concerns about big companies. It was the A&P Tea Company, kind of the Safeway of its time, getting special deals from suppliers. And so Main Street, smaller firms not getting the same or as good a deal. So I've got a picture of the, small bicycle store owner. The states acted. The California law is the Unfair Practices Act, which deals with these kinds of things. And then there's something called the Robinson-Patman Act, which did similar kinds of things at the federal level. But the idea here is much more protect the small competitor from allegedly unfair competition. So this has a slightly different perspective than the Sherman Act, but nonetheless important. Next. So during the 1920s, this is the go-go years, with 1929, of course, being the Depression. So there was very little interest in enforcing the antitrust law and making the party stop. So slow time. And then when FDR was elected, the first effort to deal with the Depression was basically to manage the economy. So the National Recovery Act basically allowed industry to create their own sort of price fixing schemes and all sorts of other stuff. That was ultimately kiboshed by the US Supreme Court. And this gentleman, FDR had come to the point where his feeling was that competition may be a better way to regulate the US economy. So Thurman Arnold, who's this guy, he was put into the antitrust division as its lead person in the 1930s. And then he basically takes off. So some of the biggest cases in the history of antitrust are brought by his team during roughly a 5-year period. And then his vision of what the antitrust division should do carried forward well into the 1960s at the very least, and maybe further. Next one. So the post-World War II, there is a big concern from policymakers about mergers. So the Clayton Act, which was that thing enacted in 1914, is amended to deal with mergers, and what it puts together is something called the incipiency standard. So basically it gives federal prosecutors the ability to go after mergers which may, in the future, in their incipiency, reduce competition. So it's a forward-looking projection of what might happen if a merger takes place. In the 1970s, there are additional changes in the antitrust landscape. The two most important here, one is that there is a structure, it's called the Hart-Scott-Rodino Act. So if you enter into a merger transaction, this has been indexed for inflation. So basically, if you do a deal, it's $100 million or more, you've got to send specific information to both the Federal Trade Commission and the United States, the Justice Department. And then both agencies have a certain amount of time to look at that. And then if there are concerns, something called a second request, which is just basically a massive subpoena, goes to the merging parties for more information. And then that there's a period of time within which that information can be digested and decisions made. And then FTC or the antitrust division can bring a legal action against the merger. The other thing that's interesting during this time period is parens patria. So parens patria basically means, for the people, fundamentally. And so this structure is basically, it gives state attorneys general under federal law the ability to bring actions which look a lot like class actions for individual consumers. So the Attorney General of California, and I used to do these kind of cases when I worked for the state AG, we brought cases, for example, there was an international cartel in vitamins. So we brought a parents patria action on behalf of every consumer in California who bought vitamins, and we recovered a whole lot of money and then distributed it in various ways. So, but this is a very powerful, powerful tool for state AGs, and is a big important part of the whole enforcement scheme currently under the law. Next slide, please. So things began to change circa the 1970s. So what I'm going to try and do is, I don't want to make any normative judgments here, but I just want to report as accurately as I can. So circa this thing called the Chicago School, there was a backlash against what was thought to be fairly liberal antitrust. Think of the Thurman Arnold School of Antitrust. This is the response to that. There are a number of scholars associated with this. The most obvious is a guy named Robert Bork. Bork taught law at Yale. He then wrote books. He was a circuit court judge, U.S. Federal Circuit Court for the Seventh Circuit, maybe in DC actually. So he was being considered for the U.S. Supreme Court, but was tossed, was rejected, and getting borked became a verb. So he was a person that was almost a lightning rod for very strong reactions. But his book is very interesting. He basically says, this antitrust thing, it's supposed to be for and supportive of competition, but actually it isn't, was his perspective. And there are a series of crucial assumptions behind the work of folks like Professor Bork and others. The first important one is that markets are self-correcting. Even if there's a monopoly or bad stuff's going on, it'll fix itself. Bad stuff is not stable. It's basically the idea here. Judges have limited competence in making complex economic decisions, so they shouldn't be in the business, and if they are, it should be frequent. This may be inside baseball. There's something called the one monopoly rent theory. One of the things that the Chicago School was very critical of were so-called vertical restraints. So for example, manufacturer decides that it's going to set the price of widgets at retail. That was thought to be per se unlawful under federal and state law. It's still per se unlawful under California law. But the Chicago School folks said, look, if you've got market power, the most clearest case, you're a monopoly, you're going to extract all the value of that monopoly at the first level. You're not going to, do anything look below you. So the consequence of that, or at least the conclusion that was drawn, is that vertical restraints really are most of the time just fine. So that ultimately led in the federal system to vertical price fixing, for example, becoming judged under a balancing test we call the rule of reasons. Large companies on balance, not bad for the economy. So this is very much a big is not bad, strong view of that. And then, at least for Professor Bork, good antitrust is limited to the most hardcore hardcore cartel behavior like price fixing, and you need to be concerned about mergers to monopoly. So less dramatic mergers that might create what's called an oligopoly, a few seller type situation in an industry. He was less concerned. Other scholars within this broad group of scholars were less generous to oligopolists, but Bork is kind of the leading light in this space. Next one, please. So post-Chicago, and there's some reading suggestions if you want to pursue this. So this is circa the 1990s. People are beginning to go, wait a minute. So the first idea here is exclusion is as important as collusion. So think of collusion as price fixing. Competitors get together and set a price. Exclusion would be a group gets together and kneecaps another competitor. So it has indirect effects, but it can have very substantial effects on a market. Think of boycotts, for example. Concentration in oligopoly industries affect markets differently. This is the idea that a handful, a relatively small number of companies, which in this structure is quite dominant in the US economy now, can be problematic and has to be looked at very carefully. That single monopoly rent theory, theoretically, from the perspective of these economists, actually only happens in the rarest of cases. So it really can't be a foundation for the broad policy that was supported by the Chicago folks. And the other thing here is courts must consider business strategies, including efforts to raise rivals' costs. So this became that last bit is the result of some progress in the world of economics, where game theory, remember Nash and game theory and things of that nature, that has been applied to economics. And the idea is that those insights have to be taken into account and should be taken into account by antitrust law. Next one, please. Current scholars. So I've given you another reading thing, which may be of interest. So this one, basically, the idea here is that, or the concept is that the Chicago School, as articulated by Robert Bork, really is out of touch with modern economics, and it's simply inaccurate. Its basic economic foundations are highly questionable, and therefore the law has to change in really substantial ways. So you're going to, the more liberal folks that you talk to are going to be talking about these kinds of perspectives on antitrust economics and its implications for antitrust law. Next one. Okay, current environment. We are in perhaps the most interesting era of antitrust in the last 50 years. There's some very big cases. My current major assignment is United States versus Google. This is a honking big antitrust case, but this is not the only one that's going on. Federal Trade Commission, state AGs, and private plaintiffs have all brought very significant platform cases. So there are cases pending against Apple, Facebook, and Google. And so these are all big cases, and they're big cutting edge cases. So that's the world you're being dropped into. I'm sure you will have conversations. People have major interests in how the antitrust laws will address the various things that are going on in big tech, but that's one thing. The other, if you would, next slide, please. So legislation is also pending. There are any number of bills. There is surprising unanimity. I mean, perhaps for different reasons, but a number of the biggest bills have very significant Democratic and Republican co-sponsors. So whether these bills can actually get to the president for signature, not clear, but there is a surprisingly unanimity on 2 points. One is antitrust isn't doing what it was thought it should be doing, and that change is appropriate. And the visions of what would be appropriate, of course, are all over the block, but this is a very yeasty period that you are now going to be a big part of. So next slide. So the fairest questions, because I deal with the common law of antitrust and moving cases and all that kind of stuff, is federal antitrust at a point of inflection? Hard to tell. Many major cases reflect Chicago School principles and assumptions. That's the baseline that I have to work off of in the federal system. But there are all of these perspectives coming in from, particularly the academy and the economists in particular, that, a lot of those cases are built on assumptions that are no longer current. So, maybe there should be change, but the Chicago School of Antitrust is still very much dominant in the federal courts. So for someone like myself, it's not quite clear where all of this is going to go. But this is a very important moment in the development of antitrust, and new legislation will certainly be part of that. Next slide. So next slide. So I'm briefly going to touch base on California antitrust law. California has a very complete set, not completely good, but certainly a set of laws that people will be talking to you about. So this is just a real quick overflight. So there is a pretty significant body of common law, like, Sir Edward Cook earlier. So for example, this is the Santa Clara Valley Mill and Lumber Company. It was a 4-county price fix in the lumber industry. And so one of the participants in the price fix, they had written agreements and all this kind of stuff, wanted to enforce the price fixing agreement and went to the California courts. This went to the Supreme Court of the United States of California, and wanted the courts of California to enforce this price fixing agreement. And the court said, "Are you kidding me? Come on." And cited literally to the case on monopolies. This is not the common law. We're not doing this. Burdell versus Grandy, kind of almost similar deal. This is Point Reyes Station. I don't know if you've been. It's one of my favorite places to bicycle to. Basically, a guy that owned a bar also owned a lot of property. And so when he subdivided his property, he said nobody that bought property from him could open a bar. So he was going to keep his monopoly on liquor in Point Reyes Station. This one also went to the California Supreme Court, monopoly against the common law of California. So, this has been around since before statutes. Next one. This is the big one. This is California's Cartwright Act. This is our basic and most important antitrust law. George Cartwright was a senator from Fresno, mid-sized business person. This time in California was very unusual. I mean, the price fixing was an ordinary course of business in many industries. As soon as this statute went into effect in 1907, companies in leather, in liquor, in various other industries, just basic stuff, ice, all were running price fixing cartels, and they all stopped. And so there's really interesting stuff from the LA Times and the San Francisco Call Bulletin about what this statute does. But a couple of things to observe here. Firstly so this is broadly analogous to the federal Sherman Act. And this language here, a combination of capital and skill. So you need two people to combine in some way to trigger a violation of California's Cartwright Act. One implication of that is if you're a monopolist, you're only one, so you don't fit this rubric. And then very briefly, California's statute is generally considered broader in range and deeper in reach than the Sherman Act. So conceptually, California law is broader and more plaintiffs oriented than federal law. And I'll be talking to you about civil remedies and criminal remedies in a moment. Next slide. So another big one is something called the unfair competition law, the UCL. So this is roughly analogous to the unfairness statute, which is enforced by the Federal Trade Commission at the federal level, although this one has been used much more substantially and much more aggressively. So this prohibits anything which is unlawful, unfair, or fraudulent. From an antitrust perspective, the most interesting, the two first ones are probably the most important. Unlawful has been interpreted to mean that you can borrow illegality from another statute. So you could bring a UCL case alleging a violation of the Sherman Act. In this Korea Supply case, it was borrowing from the Federal Foreign Corrupt Practices Act. So this pulls in statutes from federal law. In some cases have brought in treaty law. So this is a kind of borrowing statute, but it gives a cause of action, which is really quite powerful. So very useful tool across the board. Next one. Unfair Practices Act, I mentioned this very briefly. This is broadly analogous to the Robinson-Patman Act, secret rebates, below cost sales, loss leaders. Next. So this is probably more federal than I usually would show, but there are a lot of players, and let me just mention them. So U.S. antitrust enforcement as a whole, there are a number of folks that can bring actions, and that's by design. So when there was a creation of the Federal Trade Commission in 1914, it was understood that there was already an antitrust division in the Department of Justice. So the idea is that you need multiple enforcers to make sure that this very tough law to enforce does get enforced. So DOJ, FTC, states on the public side, and then private causes of action, and that can, private plaintiffs can represent, private lawyers can represent competitors, suppliers, or consumers. And all of that can be, is in the mix in terms of how to and who can enforce antitrust law. Next slide, please. Antitrust division, very briefly, civil and criminal authority, criminal powers, we use the FBI. We usually bring criminal cases only against the hardest core type stuff, which I'll describe, but basically it's price fixing. We have civil authority, so we can issue pre-filing subpoenas and demand information so we can figure out what's going on or not going on before we file a case. Next. Federal Trade Commission is unfair practices in trade, very big deal, also broad powers of investigation. Next. State Attorneys General for California, the state AG, GAs, some city attorneys can bring criminal or civil antitrust actions under California law. They can bring civil actions under federal law for injunctive relief and or treble damages. And then this parent patria authority that I mentioned earlier. And then they can also challenge mergers under the Federal Clayton Act. So that's powerful. Next. Private plaintiffs, civil actions for damages or injunctive relief, treble damages. This was built into the Sherman Act and is also in the Cartwright Act from the very beginning. The idea was that if you are going to go after, say, John D. Rockefeller and the Standard Oil Trust, you should be rewarded for that very difficult job. So that's one reason damages get trebled. I mean, a jury will give you a verdict for $1 million, and then you as the plaintiff, if you're in that happy circumstance, will make a motion and ask for the amount to be trebled. And the judge will do that because that's what the statute says. You also get your attorney's fees and some costs. So the whole thing is designed to create financial incentives so that actions will be brought. They are always expensive, have been since the very beginning. So this is not for the faint-hearted. And, at least from my perspective, these kinds of incentives make a lot of sense. Next slide. Next, very briefly, federal criminal penalties, 100 million if a corp, million if a person, imprisonment of up to a year. The big dragon, however, here for most corporations is this last bit. So, which is, you can also, in the alternative, $100 million is the maximum sort of statutory set. But if you can demonstrate as the prosecutor double the loss or double the gain, whichever is greater, the penalty can be that number. So if this is an international cartel and you can demonstrate that, the damage to the economy was 300 million, then the fine can be 300 million or 500 million, whatever. Some fines have been just extraordinary. Next slide. California, the numbers are a bit lower, but footnote, the double the loss, double the gain is also built into California's Business and Professions Code. Relatively few criminal actions are brought under state law, but it is potentially quite powerful. Next slide. Investigative powers, we have access to trained investigators, civil investigative demands. That's true for our colleagues in the state AG's office and DA's offices, grand juries, search warrants, surreptitious recordings. We have all of and this is also true for our state colleagues, have all of the law enforcement tools that are available for prosecution of any kind of criminal case. And we have those for these kinds of white collar cases as well. Next slide. Very powerful tool. This is one of the most powerful tools we have on the federal side. And that's the federal corporate leniency policy. So basically the deal here is if you or your company have been involved in a price fix, if you come in and tell us that and provide the information that supports your perspective that there was a price fix, for example, you get a lot of benefits. Your criminal sentence will be way lower. There is your subsequent potential civil exposure will be single damages as opposed to treble damages. So this creates a powerful incentive. In fact, I describe this as a prisoner's dilemma. I mean, it's in your interest if you're in a conspiracy not to talk, but if somebody's going to talk, you want to be the one to talk. So that exists. Next one. Civil remedies. We talked about this basically, a full suite of things: treble damages, fees, costs. Class actions are brought by my colleagues in the private bar. There's this thing called the Class Action Fairness Act, which now moves those cases, except for the tiniest ones. A motion can be brought to move those to federal court, but they would be focused on both federal law and state law. Next. There's some pleading requirements. I'm not going to trouble you with that. Basically, standing and antitrust injury are the most interesting ones. The idea is that not everybody gets to bring an antitrust case, and so you won't be able to do this in federal court. These kinds of requirements don't generally exist at the state level, so this is not something I think you're going to have to worry about, but just be aware that they exist on the federal side. Next slide. State law sometimes is significantly better for plaintiffs. So this direct, indirect purchaser thing, my one opportunity to go to the US Supreme Court was on this particular issue. So I represented Caltrans. So the deal under federal law was, the case involves cement. So Caltrans buys freeways. Freeways are made with bazillions of tons of cement, but Caltrans buys that product through contractors. So under federal law, only the contractor that directly bought the cement has a federal cause of action for treble damages. Caltrans, because it bought through the contractors, had nothing. So the legislature was kind enough to give us, when this issue came up before the Supreme Court and this limit was imposed at the federal level, the legislature gave us indirect relief, said we could bring indirect purchaser damage actions. And we did. And that was ultimately vindicated by the US Supreme Court. So this is a very, very big and meaningful difference for one reason people would want to go to state court or use state law. It's also the case that the substantive law for vertical price fixing, tying, protection of smaller competitors and business torts is better in state court under state law than under federal law. That is, it's more plaintiff friendly. Next slide. Next. So just be aware, antitrust is international. Some 111 countries have antitrust statutes, and all of our major trading partners have very well-developed antitrust laws. Next. The European Union is a particularly important thought leader, just for you to be aware. It's not particularly influenced by the Chicago School. It's civil-based, so our system is much more common law. That is, the bulk of antitrust is in thousands of decisions, whereas theirs looks like much more of a giant regulatory schema, where the prohibitions and how you practice antitrust law are laid out in great detail and written standards, pretty standard for a civil law kind of country or a set of countries, which is what the EU is. But they use some really interesting concepts here. One is presumptions in a powerful way. So for example, for vertical price fixing, after you've exceeded a certain market share, that is presumed to be unlawful. And the burden shifts to the defendant to show that it's actually good for the public. So that presumption structure is really interesting. And we're seeing that being brought into some of the new proposals at the federal level in the Congress. The Klobuchar bill, which I think was S225, it may have been renumbered because we've got a new Congress, but that legislation has burden shifting built in. And I think the model for that was the EU law. Also here in the United States, monopolization, typically it requires something on the order of magnitude of 60 to 65% in a relevant market. You have to show market share and bad conduct. In the EU, they have something called abuse of dominance, and that's 40%. So that changes the game quite dramatically in terms of the scope of the statute, things of that nature. Next slide. Next slide. We'll go quickly with these. What we're talking about here, you can divide the world broadly into those violations which require agreements. And here, this is Sherman Act Section 1, has to be a contract combination in the form of a trust or otherwise. So it's 2 or more persons have to agree in some fashion. Next slide. 1720, this is the Cartwright Act, also has this combination idea. Next. So it takes 2 to tango with these kinds of things. Agreements can be horizontal or vertical. They can be forced. Next slide. Because of the importance of agreement, there is a very significant body of law in terms of when we can infer the existence of an agreement. So when folks talk about these kinds of issues, these can be very, very important. So for example, if there are gas stations across an intersection, one guy raises his price for a gallon of gas by 50 cents, and then the other guy raises his soon thereafter. It's not the nicest thing to happen for consumers, but is there an agreement? Not obviously. If, however, they had been observed going to Denny's having breakfast, complained about the fact that their prices were too low, and then the first guy raises his price 50 cents, and then soon thereafter, the second guy raises his price by 50 cents, that gets more interesting. Those create the circumstances under which you might be able to infer the existence of an agreement. Usually it's meetings followed by changes in conduct or changes in prices. So this is for litigators, this is a big deal. Next slide. Rule of reason versus per se. Price fixing, you just show there was an agreement that affects price and you're done. That's per se. The agreement itself is sufficient to establish the violation. However, the rule of reason may involve a multi-step balancing test, much more complex. So rule of reason has been expanding over the last 40 years in the federal system. Per se has been declining. So that is something that folks may want to talk to you about. Next slide. Taxonomy of section, this is in the federal system. Per se, the clearest per se cases are price fixing, market division. Brian gets Berkeley, I get San Francisco, we divide the market and the product we're selling. That's market division. It can take all kinds of forms. Tying, which is, if you want my one thing, you got to buy this other thing you might not have wanted to buy from me. That's essentially a very complicated structured per se test in the federal system. It's per se unlawful. In California, it's simpler. So the rest of these are basically some version of the rule of reason, which is this broad balancing test. Next. Price fixing, very quickly, agreement among horizontal competitors affecting price. Easy breezy. Most often, this would be the kind of thing that federal and state prosecutors would bring criminally if they're going to bring a criminal case. Next. Market division. Ryan and I decide to split the market in some fashion. Next, bid rigging, basically any form of jiggering with the bidding process among the bidders is per se unlawful. Next, boycott, just because this is my favorite antitrust violation. This is named after a guy. This is Captain Boycott. He was an estate manager. He was a former Royal Army guy. He was an estate manager in Ireland. Times were bad in Ireland. This is like the 1880s. And so his Irish tenants said, you got to cut the rents. We really need some help here. And Captain Boycott chatted with the Lord who owned this property, and they decided they were going to hold the rents, and the Irish tenants started refusing to work on the farm, and they burnt his hay and did various other things. Ultimately, I mean, this is a wild story. The English crown got involved in this. The British Army came to pick his crops because this was such a threat. In any case, if competitors, if firms get together and put pressure on another firm to get a concession of some kind, that's a boycott. And it's named after this particular guy. And that apparently is quite a good likeness of the man, as I understand. Next, vertical restraints. This is, think of price fixing. I'm the manufacturer. I'm going to set the price of my, camera, my whatever at a certain level. That's judged under the rule of reason under federal law. Next. These are some of the things that have been done. Of interest to you is vertical non-price restraints, things like anti-steering provisions and things of that nature. The California Attorney General's office, our office did a vertical restraints case against Carolinas Healthcare in North Carolina. California Attorney General with a private plaintiff did some really interesting work against Sutter Health because it was trying to had various contractual provisions, one of which was, if you want any of my system, you've got to buy all of my system, which really kiboshed the ability of CalPERS and others to mix and match and find the cheapest deals market by market. In any case, those kinds of things were judged under the rule of reason. Both Carolinas Healthcare and Sutter Health were resolved by settlement, but these can be very important kinds of cases. Next, vertical price fixing. The idea here is that vertical agreements are different from and less dangerous than horizontal agreements. So next slide. Vertical price fixing under a U.S. Supreme Court case called Ligon is judged under a structured rule of reason, whereas in California, it's still per se unlawful. So this will be one of the differences. People may want to resolve this in favor of going in the federal direction or keeping it the way it is, whatever, but I'm sure you will hear about vertical price fixing next. Tying, that's if you want my one thing, you got to buy this other thing that you may want to buy from somebody else cheaper. That is a very structured analysis and requires a very demonstration of very high market share in what's called the tying product market. California law is much more plaintiff friendly. This is the leading case from 1980. So it's still much more consonant with a per se treatment of tying than federal law. Next. This is a slide basically on collusive effects and exclusionary effects. I've already touched on that. Basically, at the end of the day, you reach a situation where consumers are injured, whichever path is taken. But because the collusive effects side of this has been largely dismissed or less focused upon by our Chicago school colleagues, that this is an under-enforced part of the federal law, whereas the more difficult part of the law to enforce. So this will be something you will probably hear about from probably mostly plaintiffs folks, and some of the scholars could be aware. Next. There's some limits outside of antitrust. So for example, just to give you an example, Nor Pennington, if a group of competitors go to a government agency and say, please kneecap these other competitors. This was basically, this case actually arose from railroad company presidents going to the Interstate Commerce Commission asking that they dump on truckers. And they had this elaborate policy reason for it, but basically they wanted the ICC to require more of the truckers. Court said, look, this is two things. One is there's a break in the causation because the government is being asked to act. It's not the railroad presidents. And there's a First Amendment provision. I mean, you should be able to ask government to do things or not do things. And that exists. So, and then there are exemptions built into various laws, agricultural exemption, there's one in the federal level, and there's also one obviously here in the state of California, given the importance of our ag sector. So you're going to see these sort of statutory exemptions that are built into the law. Be aware, folks may want to get more or less, whatever, but there are these kinds of exogenous limitations. Next. Very quickly, single firm violations. We've been talking about things that require two or more, that you need two to tango. To dance here, all you need is one. Next slide. Very similar kind of, this is pretty much the totality of Section 2 of the Sherman Act. There are 1,000 cases that interpret what this means, but this is it. Next. And there are two aspects of this. One is you got to show monopoly power, that's 60+% of a relevant market, and you have to show that that is either maintained or has been gotten doing bad stuff. So John D. Rockefeller, under this system, John D. Rockefeller cannot be prosecuted for monopolization just because his company has 100% market share. He only gets prosecuted if he's got a big share plus that market power was acquired initially or being maintained by bad activities. Next. Next. I don't think you need this at this point. Next. So an example. So this is the Microsoft case. This is circa 2001 when the circuit court decision was decided. But you can see this two-element thing in action. Microsoft had roughly a 90+% share of the PC operating system market, the software market. So that was element one. And then the plaintiffs in those cases said that they illegally maintained their monopoly by denying Netscape and Java access to the most efficient channels of distribution. The court agreed with both of these elements, and only because both were satisfied was Microsoft found to have violated Section 2, that is the monopolization provisions of federal law. Next. Next. Okay, so the Clayton Act allows folks to challenge mergers. This is the language. This is going to be a recurring theme because the statutes are just very, very short. And they don't give a whole lot of direction really in terms of what we're supposed to do. But here it is. No person shall acquire directly or indirectly another person, which could be another company, in any line of commerce, in any section of the country. The effect of such acquisition may be substantially to lessen competition. Okay, so that's one element, or to tend to create a monopoly. So the tend to create is this incipiency idea. If this merger goes through, is this going to reduce competition in some way? So this incipiency thing is a giant deal. Next. Key definition is typically a market definition, which we'll talk about another day, but this is a big deal. Next. Philadelphia National Bank. This is a big deal. Basically, that incipiency standard is met, at least preliminarily, if you can show that the resulting market share will be substantial. So this is a federal presumption created by the U.S. Supreme Court. So it must be enjoined in the absence of evidence clearly showing that the merger is not likely to have such anti-competitive effects. So just a really interesting burden shift, and still quite controversial. The most conservative pundits in the antitrust space would love to eliminate this. Every merger case I've done, I've led with this because for obvious good reasons. So, just an interesting example of a presumption coming into play in terms of the law. Next. There are federal and state guidelines in terms of this. I'm not going to talk about the HHI screens at this point, but there are these very extensive guidelines. They are in the most recent of which is 2010. The expectation, this is being worked on right now by both the FTC and the Department of Justice. Whether we have an updated set of guidelines to talk about by the time you and I are done with this 6 months from now, not yet clear, but it's very possible that you will see a very substantial new version of these guidelines within the next few months. Next. Next. And next. I think we can cover that another time. Efficiencies. Usually when you deal with these kinds of cases, there are lots of claims about efficiencies. And that's a good advocacy on the part of those defending the merger. But the standards that apply, they are independently ascertainable. They have to be merger specific, and the burden is on the defendant. Okay, so this is another burden shift situation, but it can't be just in general, we might be able to do this. Only the merger allows us to do this particular good thing, whatever it is, a good efficiency enhancing claim might be. So, important to be aware of. Efficiencies will be something that people will talk to you about in various contexts. But this is kind of an example of a situation in which burden is allocated to presumably the parties with the most knowledge about what these efficiencies might involve. Next. Hart-Scott-Rodino Act we've talked about. Basically, this is a procedural structure, which basically says if you're going to do a merger of a particular kind, you got to give notice to the federal agencies. There is nothing like this in state law. When I was in charge of California's antitrust unit in the AG's office, when we got wind of these kinds of things, I would use our administrative subpoena power and demand that I get the same stuff that went to the FTC and the U.S. Department of Justice. So there are ways, but this structure is one of the most important procedural devices that exist for addressing mergers. And California law does not provide for that currently in an explicit kind of way. Next. Next. We're almost done. So the small guy, remember, so mostly we're talking about efficiencies, ways of improving equity in the market. There are these very specific statutes that were created to protect smaller competitors. So the Robinson-Patman Act we've mentioned, the analogous California Unfair Practices Act, and then business torts. These can be very powerful tools, and they sort of have their DNA in fairness, ideas of fairness and tort law. So they just start from a different place from the current sort of econometric kind of analyses that we typically do in antitrust. Next. I think we're done. Thanks for your patience. So do you have questions or, oh my God, why did that guy talk to me for so long? Is there anything I can respond to in terms of anything that might have come to mind? You're going to get a lot more detail in subsequent lectures.
Commissioner Huebner.
Yes, Professor, thank you for the helpful presentation. I have just one question, which is, you did reference on a slide current platform cases.
Right.
Now, clearly the substance of the business, the technology is new, but are there analogies in prior antitrust history to platform cases? Putting
Great.
technology aside.
Yeah, no, great question. I mean, every time one addresses a new industry, tech is the most obvious one. When we did the initial Microsoft case, there was a suggestion of, well, tech is so unique, you can't really, the antitrust laws should basically not apply, was the one theory. If you look at the Microsoft case, the traditional kinds of standards about how do you protect the competitive process, and in that particular case, there were these highly exclusionary contracts that Microsoft had entered into with the most efficient form of channels of distribution. So it turned out, when you really looked at it, and certainly the antitrust division and its co-plaintiff states, including California, focused on the traditional aspects of this. So we basically said, this looks a lot like John D. Rockefeller in terms of what they're doing. So the fact that we're dealing with, cyber kinds of markets, it still can be analyzed looking at whether it's exclusionary or exclusive or advanced competition or not. That will be tested. I mean, we've made very similar claims in the Google case. If you were to look at our complaint, it basically suggests that it's exclusionary contracts that keep Google in its current situation. So I think there's a lot in the common law tradition and in this very rich set of cases that we have, but it's very much case by case. I mean, one of the things that's sort of intriguing about antitrust is America sets industrial policy basically through a common law litigated process, which just is fascinating to me. How would you, these are some of the most important economic decisions that a country can make, and we make them in trial courts. But we do look at, and I think have been reasonably successful in using the case law, in ways that allow us to assess new technologies.
Rick, Victor, I think Victor was first.
Yeah, that's fine.
No, you were first, Rick.
Okay, so big picture, it sounds like companies could grow, take over large shares of the market because they're the best at doing whatever it is they do. But in order to be in violation of antitrust laws, they have to be taking some affirmative action, a contract, price, whatever it is that either negatively affects consumers or negatively affects other people in that market before they would be in violation of the law. So it's not just size, but it's some kind of actions that result in negative outcomes. Is that?
Yeah, absolutely fair characterization. I mean, the apropos of that, there's a case from the 1940s, United States versus Alcoa, and Learned Hand there was the circuit judge dealing with that case, and he basically said, look, we can't encourage people to invest money and be innovative, and then penalize them if they succeed. So that's kind of that's basically the theory. But there is, but there's nuance here, which is the larger you get, some of your contracts that might have looked not that difficult or problematic when you're got 5% share, that becomes much more exclusionary when you've got an 80% share. So you've got the courts take that into account, and some of this stuff may be fairly subtle, but the basic idea, you've got it in one. Absolutely.
Victor?
Yeah, I know this is an introductory lecture, and maybe it's too early to ask this question,
Ask
but I'm
away.
curious. I'm curious of what you think of New York's antitrust law. Is what weighs heavily on my mind here is we're being asked to do something that New York spent many years working on, and they wrote legislation which just stalled, and nothing became of it. And so that's always in the back of my mind. Are we going to spend 2-3 years on this, and it just will not be passable legislation or effective legislation? So do you have a grasp on what happened in New York when they went down a similar road?
You know, I really don't. I mean, I followed the antitrust press fairly closely. I mean, apparently it was the chairperson of a particular committee. And then when it actually got to votes beyond that, either that committee or broader, they just didn't have the votes. I think that's fundamentally a political question that interfaces with what it is they came up with. You know, I think you could probably, you know, do some reforms that would go down easy or easier, and then you could swing for the fences and you might run into problems. But I think I'm presuming that, you know, given the makeup of your commission, you're well connected with the legislature and you're going to have a sense. But it may be the case that you might want to just write, you know, a bill for the 21st century and, you know, just try and make it the best you possibly can. That by itself would be a potentially useful activity, I would think. But in terms of actually getting something passed, this is perhaps the most significant set of statutes in the country because it directly affects so much commerce. So you're going to have interested parties. You will be shocked at how many people are going to want to come talk to you about, you know, their special situations. So, you know, I think as you know, since your process is so open, I think you're going to have a sense of what's possible and what's less possible as you go through this process.
Okay,
Other
thank you.
questions from my colleagues? Professor Green, I wondered if you could unpack the comment you made a moment ago about the bill for the 21st century. My macro question is, what is the impetus for reform in this area of the law? If you ask the plaintiffs bar, they probably, you know, want antitrust law to be more aggressive. If you ask the, you know, the corporate stakeholders, they would want it to be less aggressive. I'm wondering if there's a consensus on, you know, something in particular about antitrust law that requires a 21st century bill.
Great question. I'm gonna probably dodge on this one. I think it depends on who you talk to. So I think that there are, and I can send you an article on this, but there are basically 3 camps.
I would read that article actually, so please do send it to me.
Okay, well, so there are basically 3 camps. There are the traditionalists, which are, you know, everything is just fine and dandy. Don't bother me with any changes. And those people tend to be more Chicago-y kind of folks. So that's one camp. The next camp would be some version of, look, our experience and the emerging consensus in the academy is that at least some of our doctrines at least in federal court, are not fully supported by the best economics in the country. That would suggest that a bill for antitrust law for the 21st century would take into account those new perspectives, which is what you see in like the Klobuchar bill. At least that's the effort. Then the third camp are what are sometimes referred to as transformists. So when you look at the actual debates, for example, in the Sherman Act, for this case I did on the indirect purchasers, I actually read all the debates on the Sherman Act, and it's rich. I mean, it's just a petri dish of progressive era perspectives on the importance of controlling corporations, people and small businesses being treated equally with others, et cetera, et cetera. That would suggest a very substantial transformation of the antitrust laws into much more of an equal justice-y kind of thing. So, you know, any one of those places you could stop at, but I think either the reformists or the transformationalists would lead, if you landed on one of those squares, you would want to change the current law to some degree.
Thank you.
Yeah.
Anything else from my colleagues? Brian.
Yeah, integrating a couple of the commissioner comments. Commissioner Hebner asked about whether there are analogs of the tech platforms, and Commissioner Carrillo asked, what do we mean by a 21st century statute? I'm wondering the extent to which there's a sense that the tech platforms present novel questions that would need to be addressed in a 21st century antitrust statute that don't have good analogs in other areas of the economy. And I'm wondering, for example, like Amazon acts as a marketplace, selling other people's goods. It collects data on their sales, and then it introduces its own products in direct competition with its. So it's operating as a platform and a participant in its own platform. Is that something, or are there things similar to that are just new, that haven't been adequately addressed by antitrust?
You know, I think that particular example, one of the bills that got out of, I think the Senate Judiciary Committee, the U.S. Senate Judiciary Committee, it was, I think, voted out 22-2, was essentially an equal treatment on Amazon bill. You know, the idea that you know, small businesses should get the same treatment as the big businesses on, because Amazon is both a seller of goods itself, which is interesting, and it's a marketplace. And, you know, so the idea fundamentally behind that bill is that if you're the marketplace, everybody gets the same treatment. So that kind of legislation, that sort of thing, I think would be very difficult for current antitrust law to really get at. I mean, this would be a kind of, so the closest analogy, which is highly imperfect, would be the Robinson-Patman Act. So, you know, the small bicycle dealer on Main Street should get roughly the same deal, you know, setting aside differences of cost to give him bicycles as Walmart. So that kind of equal treatment idea is tucked away into that, at least in terms of goods being sold at wholesale. But the idea of equal treatment, I couldn't give you an obvious theory where I get there using the tools that I've currently got in my toolkit. So that might be something like that. The other aspect of this is that, you know, current antitrust law, and probably will be this for a long time, is a common law process. So you've got all of these major cases going to trial very soon. I mean, this Google case that I'm working on, we have a trial date of September 12th of this year. So that's going to test, that'll be yet another test. Can we use these structures that, you know, I'm very confident or powerful tools? Can we apply that to a Google as we did to a Microsoft? I mean, we're gonna know a lot more in the next 2 to 3 years. So you're gonna see stuff in this arc of activity that you're involved with as to how successful current law might be with respect to some of these big platforms. And you know, I mean, the platforms, by the way, I mean, they have their own arguments, and you should hear them in terms of, you know, Amazon will tell you they're very pro-competitive. Google tells us that pretty much daily in my work for the Justice Department. So, and you know, they have legitimate interests, and you know, they're important companies for California.
Anything else?
Well, I'm sorry, Professor, I would ask about your final comment. It almost sounds as though you're framing being an important company for the state as somehow suggesting an exemption from antitrust. Or am
I-
I misunderstanding
No,
what
no, no,
you
no.
just
I,
said?
I wouldn't, I don't think that's a principle I would think that you can really adopt. Because these companies are important, but you also have more consumers in California than anywhere else in the United States. And this is the fourth largest economy in the world. So I think you want to be fair to everybody and be thoughtful, but no, I don't think that's a principle that I would be suggesting you to adopt.
Going once, going twice. Then I think we can thank Professor Green for that very thoughtful and
Thanks,
thorough
guys.
discussion. I would be interested if you had any materials that you wanted to send along. As an academic, I do read articles. So please send me whatever you think is worth reading.
Okay, I'll send you a couple, and then if let me know if those are turn out to be interesting. And I have quite a library here, so
I'd appreciate it.
okay.
Thank you,
Thank you
Professor.
all.
We
Bye
will
bye.
see you next month. Thank you.
Bye.
Anything else, Brian?
No, I think it might be helpful at some point if less than a quorum of you want to give me feedback on how the presentation went for you and what resource it is, whether it's a good resource, whether you want something different. The memo lists the proposed schedule for future topics, so you can take a look at that. But if you just want to shoot me an email or at some point or something and just say if you have suggestions for improvement, then I could pass them along to Professor Green.
Anything else from my colleagues? Seeing no further business, I believe we stand adjourned.
Bye.